Childhood, growing and developing years of a person, this is meant to be a highly important time to create morals, fundamentals, and skills necessary to be a success. Instead, the trauma CPS creates in these young minds set a path of disaster, and statistics prove it. In nearly 90% of their cases, the trauma is unnecessary. Time is the one thing that can never be given back. CPS takes away moments in life that can't be replaced. The time just keeps going, doesn't mean a thing anymore. They left as children, and it's up to them when they come home if they know who you are. Each second away is time you will never get back and keep getting older.
Studies are leading towards incarceration.
Now comes the honorable judge in the halls of justice, where the Constitution will hold strong, and your rights to life, liberty, and pursuit of happiness will trample CPS for all they have done to your child.
The truth and corruption that's revealed to you is enough to make you sick. This is not America we were sold.
Children are being taken from families at the rate of 1 a minute. It needs to be stopped.
It's time to wake up and abolish CPS.
Psalm 127:3. Children are a heritage from the Lord, offspring a reward from Him. This suggests children are a precious gift from God to be valued and cared for.
In the United States, a child a minute is taken into DHS, CPS, and so on custody. The reality is their picks are already selected, you just don't know it. Being perfect no longer matters. It's what the adopting families are looking for.
Who is it stealing the children, you ask?
From caseworker to the White House, the buck stops at all levels, just not where it is supposed to be. The services your family needs, we the people have paid for to ensure your reunification. Title 4 says, reunify at all costs. United, we stand means nothing to us when it comes to family values. Children are being ripped away from their families. Parents are reverting to addictive behaviors to cover the pain. The trauma caused by child removal is just being recognized, and the results are atrocious. Termination of parental rights is not healthy for anyone, just profitable for the people enforcing the lie.
It's time Washington listens to the cries of our children, the wails of their mothers, and the rage growing in the fathers. These are our children. Keep your damn hands off them. We are coming to act on the behalf of the children God gave us to protect, and you kidnapped.
In the United States, CPS makes upwards of $3 billion per day on trafficking and selling our children. The corruption may start with the caseworker, but goes through the judicial system, passing the governor through the Senate and into the White House. The entire system has a hand in the business known as CPS.
Our children are stolen every minute of a 24-hour day. They are being robbed of their innocence, their trust, their happiness. As parents, we are isolated and betrayed by a government we trust. states are balancing budgets on kids' lives. Only 12% of the kids taken will be reunified. Title IV funding is being riveted with fraud.
What's up, everybody? Happy Friday night. This is CPS Punisher here, live with CPS Victims Hunting Justice. Hey, don't forget to like and subscribe. All of that stuff, share with your friends. We got important information that we're getting out to people, and we need you to be the ones that are passing on the information. Tonight, what we're going to do is welcome, first of all, the Twitch people that are watching. We want to thank you guys for joining us. We're happy that that's happening. That means more people are hearing and knowing about our show. But also, and we want to welcome everybody else that's here. So make sure that you like and subscribe. We've got the chat thing. That's right. It's going to go like this right now. Right here is the chat window. So make sure that you have questions, things that you want to ask us tonight. We have our constitutional lawman Charles in with us. Of course, as always, we'll have Herbert and Melissa. And this is going to be about you guys. So make sure that you ask questions away. We'll have answers for you the best that we can. Look, we are trying to attack them with Title IV funding fraud. That's what we're trying to do. So make sure you abolish CPS. Make sure that you contact us at abolishcps.com at gmail.com, and we'll send you that letter so that you guys can start sending it out to your senators, your congresspeople, whoever that you can send this letter to start getting them investigated for their fraud and Title IV funding. Believe me, they are doing it, people. So you don't think that you're like, well, I don't know if they're going to do it or not. Because, I don't worry about it. They're doing it in your case. Be sure of it. Probably, most likely, 100%. Make sure that you FOIA that. Herbert, I've sent you the link twice, buddy. Sorry about that. So make sure that you guys do that. abolishcps.com at gmail.com. Make sure that you email us so that you guys can get this letter and send it out to others. It's very important. And, I'm not even going to waste any time now. I'm going to bring out Melissa and Charles here. And let's get it on. Guys, how we doing tonight?
Oh, a little bit better than the past couple of weeks.
Yeah, you had a tough run, Charles. We've been attacking you. Yep.
Hmm?
You've had a tough run with them attacking you, the man attacking you?
Yeah, I'm kind of contemplating the counterattack. We're talking too detailed about it, but I sometimes spend a lot of time thinking about strategy, and that's what I've been doing the past 2 weeks.
All right. Melissa, how you doing tonight?
Oh, I'm good.
You're good? Anything good going on with you? Any new stuff?
Nah, just research like always.
Just research. Hey, what are we finding out? Good about Title IV funding? Anything good? You got any new stuff? What's your thoughts? What are we doing with attacking them?
Well, I think it's just a matter of figuring out if the rules that we read are rules in a way that they are criminally enforceable, if they're, or more than criminally enforceable, but enforceable in a way that we can sue them under something heavier to argue fraud. Because at this point, they're kidnapping the children, holding them with no intent to give them back, even though Title IV says that the requirement is that the funds must be used for reunification, and that the funds cease at the point that they filed for termination. Correct. So, and it also says that they only have a year to make up their mind. So in cases like mine where there's been no minds made up and we're going on 2 years, and I bet you they're still getting those paychecks. So realistically, it's just a matter of figuring out how to put, dot the I's and cross the T's and find a new way to fight them.
Right. Charles, what does that mean? So earlier you were just talking to Melissa and I about if it was law or if it was in the UFC or the USC codes, or if it was. So how do we use their own rules and regulations and such against them? And can we, or what is that? What is the process for this?
Well, you first have to read it and see if if there are any remedies written into law. And in a lot of the Code of Federal Regulation, there's not. And as a matter of fact, in a lot of statutes, there's not. A lot of times, the way politics works is that politicians think, we really need to do something about this, and so we're going to do something about it. We're going to pass a law. But they don't really provide a remedy. They don't build in any consequences to the violation, and the people who promulgate the Code of Federal Regulations, they do this even more. I've got a case that we're working on in California right now, where we are talking about consumer law, and in particular the violations of the Code of Federal Regulations in the unfair debt, the Fair Debt Collection Practices Act, the FDCPA, and the regulations sound great, but they have no consequences built in at all. And so, in the lawsuit we're doing, we're trying to argue that the court needs to infer remedies for the violations of the Code of Federal Regulations. And if you think about it, when the Civil Rights Act was first passed, it only applied to the states. The only remedy provided was a right of action under 1983 and 1988 against the states and state actors. It wasn't until the late 1960s, early 1970s that the Supreme Court said that the existence of this remedy against the state implied that there should be a parallel remedy against the federal government. And so the Supreme Court of the United States ordered that the Civil Rights Act action be extended to federal officers in a case called Bivens versus seven FBI agents. And that is part of what the judicial process does. The judicial process is capable of adding to the law, and I'm looking at the document you sent me just now, and I think we've talked about this a little bit before, that federal law and federal regulations is more protective of alien children, immigrant children, than it is of national children, of citizen children.
Right.
And a lot of this comes out of Title 8 of the Code of Federal Regulations, which is immigration and nationality aliens. And then a lot of it is from similar statutory stuff is from Title 8, and then a lot of the regulations are from Code of Federal Regulations, Title 45, which compared CFR with Title 42, and I haven't read a lot of these sections yet, but they're saying that this is just a report, basically, and it's a finding of non-compliance, and it doesn't suggest any remedy at all for a lot of this. And so you have to ask the court or ask Congress to change the law in order to authorize a remedy for violation of things like, failure to interview a child within 24 hours of their arrival at a certain facility. I mean, what are the consequences? I mean, imagine if criminal law were imagine if criminal law were written like the Ten Commandments, and all it said was "Thou shalt not kill." The Ten Commandments doesn't actually provide any remedy for "Thou shalt not kill."
Right.
You have to go on and elaborate, what is the penalty for killing under certain circumstances, and that's exactly what we have to do when we're talking about this. You can't just say you violated a regulation, and so we win. You have to say the law provides this, and this, and then when all these circumstances are ignored, in the interest of justice and equity, a person is entitled to enforce. Maybe it's a right to an action for injunction, to force compliance. Maybe it's an action to divest certain agencies such as CPS with jurisdiction, to handle the case at all. If they aren't going to follow their own rules, perhaps they should be completely disqualified from involvement. But what you have to do is you have to propose. If the law doesn't propose a remedy, if the law doesn't propose any consequences, provide any consequences, you've got to point that out to a court or to your congressman and say, or both, and say, hey, this law is meaningless. You enacted this law to make everybody feel good, but it doesn't make me feel good because it's just paper. It's paper without any consequences, without any teeth. That's probably the best way to put it. Law, declaration of purpose without teeth.
Well, isn't that the case then in all of these things? So when we look at, let's say, the probate code for adoption, so we have all of these codes and all of these rules that they're supposed to follow. They don't follow them. There's no remedy about these. There's no nothing. So what do we do? Like, or is that what the courts are for? Like, this is when you get your kid taken, for instance, this is the rules for the guardian ad litem.
If the written law doesn't provide any remedy, then you have to go into the court and argue and say, we propose, or I, Darren Y, propose that this court should declare that the defendant has done X, Y, and Z, or failed to do X, Y, and Z, and that as a consequence, this court should impose a penalty of no LMN.
And hence we made case law then, right? That's how case law comes into effect?
Yeah, exactly. This is called the common law process. And the resources that you're using are the Code of Federal Regulations and the United States Code. And in this document you sent me, it's specifically about New York, and they're extensively citing New York and saying that New York law wasn't followed either. And there are all these things. Like I'm on page 16. The provider is required to maintain, and the child is required to sign, and the provider is required to maintain something in the child's case file. P&P Manual Section 3.01. Well, if they've never done that, what happened? The law oftentimes does not say, and so you have to say, in my case, in the case of my children, or in the case of whoever's children, the consequence needs to be either a dismissal of all proceedings, or an injunction to follow the rules, and the court was ordered to follow the rules, you have to propose something the court can actually do. And the court could or either enjoin CPS or some other organ from taking any further action, or they could command them to do what they're supposed to do. And so, what is it you really want to happen? And you've got to make an argument to say that is a just result, and it's consistent with the purpose of the statute and the regulations, and it's in the buzz phrase, it's in the best interest of children. So I mean, you have to get used to basically thinking about law as process. Law is not static. Law is about formulating problems and trying to solve them.
So, all right. So then that would be it. So because there's no remedy on these things, then this is why we got to go to court. We fight them in the court. They come up, they make up a ruling. The ruling becomes case law, so on and so forth. And then that becomes.
You basically need to think through your own case and say, what is the result you want, and why is it consistent with existing law, and does the court actually have the power to do it? So you've got to go through that entire analysis and show precedence on all.
Right. Right. So that's good stuff to know. So if a caseworker breaks one of these rules and you're in the middle of one of your investigations, what do you do? How would you handle that, being a parent, being in that investigation, being in that current moment?
Analyze it in context and say, what's the best solution? Would you rather have the caseworker divested of any power or commanded to follow the rules? Those are two very different solutions, right?
Right.
Those are two very different solutions. In the one case, you're saying, hands off. You didn't follow the rules, so get out. And in the other, you're saying, you didn't follow the rules, and so you must follow the rules.
Right.
Those are two totally different results and two totally different scenarios, and you've got to advocate for one or the other, and you've got to use the resources of case law and comparison with laws that do have teeth to them to say, exactly like the Supreme Court did when it extended Section 1983 to apply to federal officers and Bivens. It said it makes no sense at all that Congress created a civil rights statute where you could sue state officers, but federal officers who do the same thing are immune. That just doesn't make any sense. It's not fair. It's not even protected. It gives way too much power to the federal officers. So we're going to say that 1983 will apply from this day forward to federal officers, even though it wasn't there. And what Congress did then was Congress then amended the Federal Tort Claims Act to include the equivalent of Bivens results, and basically they made it the standard format in Bivens and various state tort claims act is you have to present an administrative demand first, go through an administrative process before you sue.
Okay, so there's no quick fix then. If your caseworker is breaking these rules, unfortunately, you're not going to be able to get your kid back right away. You got to go down a whole nother road of so first of all, you got to find out if there was in fact any remedy to them or any consequences for them.
The first place is, if you say that there's a rule, you've got to read everything related to the rule and see if there was a remedy. I hate to say it, but in a lot of Title 42, and a lot of Title 15 and 16 consumer laws, banking laws, there is no remedy. There is no remedy. But a lot of these laws are just passed to feel good and make make the politicians.
Right.
You know, we've done something. We've passed a law that says everybody must, you know, wear shirts made of inflammable material when they're working in a furnace.
Right.
They don't. Nothing. You know, and but you know, Congress could have said if you don't wear inflammable shirts in a factory, then the factory will be closed down, or the factory will be fined $100 a day, or $1,000 a day, or $1 million or something. But there has to. But if the law isn't there, then the proponent of a change, an extension, modification, or reversal of existing law, or to make new law, has to have the proposal, and it should make sense, and he or she has to be ready to argue it to a court. And I mean, the example I just gave you was if CPS hasn't followed the provisions of these regulations, you know, does that mean they lose all power, or that they must be compelled to comply? And those are such radically different situations. You know, they're basically incomparable.
Okay, that's so. Would I'm trying to look for my. I want to read you this letter that I wrote here for us for you to do that. But so, would you consider that? So, for instance, all right. So we know that that's there. Sorry, I'm just galloping. I'm trying to think about 10 different things at once here. And Kenship, yeah, we will talk about that in a minute. Kenneth, also, would you like to come in and give us an update on your case? That would be really cool if you could give us an update. I can send you a link to the show and email you, but sorry to change it up. But anyway, so I use this. So this is the Oversight Committee's report, Charles, right here that I have for the state of Maine. Different findings that they had that they use. Obviously, these are the rules that they go by, right? And the Oversight Committee is a bunch of legislators that work and, you know, make sure that the laws that have been put in place for DHS in Maine stay working, and they're making sure they're doing an audit and all of that, right? Now, how do you use findings by the overseers? For instance, when they say that, you know, this is the rules, this is neglect, this is what it says. So, for instance, here it says, having a solid case with proper evidence is necessary to meet the highest threshold required by the court to justify a child's removal from their home. Here, like, so then there's here. They may, it says, this is generally a family's engagement with caseworkers during an investigation is voluntary. Parents can decline to speak with caseworkers or to allow them into their home. Additionally, parents may decline or to allow their children to be interviewed. They may also choose not to sign releases permitting caseworkers to obtain information from their mental health, and substance use treatment providers. Parents also do not have to participate in any services recommended by DHHS. The department, with advice of the Office of the Attorney General, may seek a court order to compel the parents to engage in some of these activities. With the parent engagement being largely voluntary, CPS caseworkers instead rely on social work skills to build rapport with parents and encourage their participation with agency and investigation process. Okay, that right there comes from the Oversight Committee, which says clearly you do not have to do a damn thing that these people say. And then there's furthermore goes down the line. It says that most of that, if you don't do it, can't be held against you. But in the courtroom, they're holding this stuff against you. What's up with that? Does this hold no water when the overseers talk? Is there no I mean, you're really reading out of the lion's hand here. I mean, you're reading out of the food that fit you, right? Because the overseers are the ones that know the laws that they wrote, right? And they're the ones that are making sure that DHHS is in compliance with those regulations. Well, if I went to the courtroom, they say that this doesn't matter because this is just the opinion of an oversight committee. So how does that work?
Well, I mean, I'd have to study it to know how it works, and I haven't.
I'm just looking for like a vague, because I advise all people to go to their state's go to their websites and find these, because there are investigations and studies into your local DHHS, your CPS, and all of this stuff.
And
There's
maybe,
a lot of info in here.
maybe sometimes they consider what the consequences should be, right?
Well, that's what I'm getting at. So if they're saying here, if the, like, for instance, here's another thing. The Oversight Committee says some studies may indicate that a family or a child needs community services or support, but do not meet the definition of child abuse or neglect. Examples are living in poverty, including lack of food, clothing, or shelter that is not injurious to the child, accidental injuries, even if regular and reoccurring, parental or prenatal substance use, physical or mental impairment of the parent, including substance use, if it has little or no impact on the child, isolated incidents of domestic violence when the child was not present, and physical discipline like spanking, as long as it does not cause bodily injury. Now, this is saying that the definition of neglect or abuse is not those things, but I guarantee you 9 out of 10 people that are watching this that have caught a case from DHS, one of those things are on that list. And they're saying right here, that is not it. So how is it that they're getting away with doing these things, but yet the people that make these laws that oversee it are saying this is not it? And there's definitely a gross misinformation between the lawmakers and the law producer or the law enforcers.
At this point, you're saying that the law allows too much discretion.
Well, I'm not saying that at all. What I'm saying is the lawmakers are making it one way, but the courts are enforcing it another. So the lawmakers are saying, no, this is not neglect or abuse, but the courts are saying it is.
The judges have the discretion to disregard these regulations because there are no built-in consequences.
Okay.
If there were built-in consequences, if the law had teeth, it would be one thing. But when you just have these declarations of intention without consequence, without penalties, without remedies, then the judges just have discretion whether to follow it or not. Thou shalt not kill.
Right. Well,
but
let's talk about that on the aspect of, so when Herbert, let's get Herbert in here to talk about this for a second, because this is interesting. Herbert, let's get you in here. So when Herbert's a cop, when policeman Herbert comes out, right?
Herbert's here.
Herbert, all right, you got a little reverb, buddy. You might have to switch it, but it's okay right now, I think. If that's too much to people, please let me know and we'll do something here. But Herbert, so you come out as a police officer, you don't know what you're charging me with. You know what crime you're charging me with, but you don't know what the consequences are, right? So that's left for the court to decide.
That's correct.
But you don't have a book that says, if you arrest me for something that says, you arrest me for stealing candy, but the lawmaker says, arrestable offense is not stealing candy, you can't arrest me. Correct?
If the only way I can arrest you for stealing candy is if you're the merchant and you say that person that you stole the candy. The merchant could have said, "Take the candy."
That we stole candy.
Yeah. No. The thing is, you have to have a complainant. The complainant would be the merchant, and the merchant would say, "Darren stole that candy, and I want him arrested. I will come, and you're the person that's pressing charges, and I will place him. I'll take him in for you stealing candy." But if the merchant says, "Darren, go ahead and take the candy, it's all yours," then you didn't steal the candy. You were given permission to take the candy.
Right. So if the law said you can't arrest me for stealing candy, even though it's stealing, it says no candy, the law says you can't arrest me for it.
Yeah, I think that you're saying something else. So you're talking about guilt versus innocence.
Hold on a minute. Let me quickly. I'm flipping you out, Herbert. Hold on. Go ahead, Charles.
I think that there are two different issues. He's talking about guilt. Herbert's talking about guilt versus innocence.
Well, I'm just saying the fact that he can press charges for it, because this says that neglect's not any of these things. And this is what the overseers say, the lawmakers say, that that's not neglect.
For every crime that Herbert ever arrested anyone, most likely, there was a penalty built into the law. And there was, a jail term or something built into the law, or a fine. And in most of these regulations for CPS or public health and welfare or consumer law for that matter, there is no fine or jail penalty or consequence of any kind. It's just a declaration of purpose, a declaration of policy, and if you don't follow it, well, that's really too bad. So I mean, that's the distinction. Herbert is used to enforcing the criminal law, which always criminal law has teeth. That's how it's structured. Every time they make something a crime, they will attach a punishment to it, common punishment. And if you have regulatory standards that are just policy guidelines, they often don't have that. And that's why I'm saying you have to use litigation to modify, extend, or reverse existing law, or make new law, so that the violation of these rules will have a consequence.
So that's what we need to start doing, because there are no. Now, would that be a way? Is that how they're suckering themselves into immunity too? So they're saying, whoa, because there's no consequences anyway. So their only thing is to play offense and say, and on top of this, we're going to get some immunity, so you can't do anything against us anyway. But what are they seeking immunity
and
for?
Darren, that's why we look up the case laws where they have the remedies listed in them.
Well, except they don't always have any remedy, right?
Right, which then leads us to make the forefront for it. Right. But my question is, I guess I don't know if I'm not asking it right, if I'm not getting at it right, but what I'm asking is why do the lawmakers say that these things are not neglect, but yet a DHS worker can come along and say that it is, and then bring it to the court? The law is defined by the lawmakers, correct?
Usually, it's supposed to be.
Right. So if this says that these things are not neglect,
a lot of times they don't really define it.
Correct, understood. And I'm, like we're playing in a perfect world scenario too, obviously. But if these say that these are not the definitions of what these things are, then why can they use this?
Say it again? I didn't understand it.
What simply, if this says, if the lawmakers say this is not neglect, why are they allotted that privilege to go ahead and second guess the law? Because the lawmakers come from the people, right? People, the law, we make the laws, we vote on these most of the times. They're in a little things where we vote.
A lot of this voting is just showmanship. It's just to say that we've done something when they haven't really done it. I'm being cynical here, but
no, absolutely, and that's why I'm not looking for anybody to take my side and be like, yes, Darren, you're right. Absolutely not. I'm looking for an answer or a remedy to this situation, because I'm feeling like not only is the Title IV stuff, very important, and they're doing that as fraud, but a lot of this is, because there's a lot of this that we can use on our side as parents that say, no, you're wrong, but yet we're not able to enforce it. And we should be able to go somewhere and enforce it. And then what leads to even this is, what's the sense of the OIC doing, or the OIG doing an investigation on this stuff if there's no remedy to begin with? Like, so what are they investigating? And what is that what they do the OIG investigations for? I'm just having a hard time where all of this stuff says that what they're cutting all of our when they're terminating all of our parental rights as parents. And a lot of these laws don't state that they can do that, just like Title IV funding, like we read about earlier. Reunification. While in reunification, that's the only way that you are to obtain funds from Title IV funding. However, we've seen documents that say that their intentions from the moment that they pick you up is to terminate your parental rights. But yet these people are still working under different, ways, color of Title IV, I guess you'll say. They're not going to let you have your kid back. They are totally severing your ties, your bond. You're doing all of the things that are needed to be done in lieu of termination of parental rights, short of saying it, or they're even doing it. They shouldn't be getting these funds because it's only for reunification purposes. So what do we do? Where are we falling short? How do we get these people into the penalty box?
I'm just saying, you have to ask somebody to impose a penalty. You can ask a judge, you can ask Congress to change the law, you can ask state legislature to change the law, but most likely, if you're in court, you have to ask the court, and you're basically going to have to frame a declaratory judgment to say that the law is insufficient as written. It creates a wrong without remedy. Damnum, the Latin phrase is damnum absque inioria. And you have a wrong without remedy is a very frustrating thing.
Right.
And yet the law is the law books are filled with them, and people think that this stuff is absolute, but it's not. They're basically guidelines, and that's what I said about 10-20 minutes ago. About too much judicial discretion. The judges have pretty much absolute discretion whether to use any of these rules or not. And so that's why people get so frustrated with the vast power judges have, and it seems to have no connection with either the statutes or regulation. And,
hey, Melissa.
In other words, the law is like frequently like, V for victory. We're going to conquer child abuse by enacting all these rules, and we're going to give the judges the power to do it. That's basically what you got.
Right. Hey, Melissa, I can't, for some reason, hold on, I can't see the overlay, the chat things, so I can't put them up on the board. If you could handle that, that would be really cool, because I know Kenneth's been saying a lot, and I'm going to send Kenneth a link to give us an update. But Charles, so what you're saying is when I'm in a case, I'm telling these people, look at this stuff and find these rules and try to use them in your favor. So unless they honor them with DHS, if DHS looks in and goes, oh, geez, I guess that's not neglect. There's that way, right? You could go there with the rule book and say, according to the rules, you guys aren't following them, and then they can make that decision on their own, correct? Like that's one way that you could try to enforce these rules.
As I say, I mean, in this, I give the example of a case I'm working on in California, where the plaintiff wants to enforce regulations from the Code of Federal Regulations about the Unfair Debt Collection Practices Act. And we list in the complaint all the regulations that have no remedy, and we say that that when they're not following these remedies, there have to be consequences. And here are the proposed consequences.
Okay.
That basically when they don't follow when the debt collectors are not following these rules, they lose all rights to collect anything. That's a very and at any time they have successfully collected debt, they have to give it back. That's the relief we're looking at. That if they don't follow the rules, they lose their money. That's a very powerful incentive to follow the rules. Probably one of the most powerful incentives.
Correct. Right. And if that would be either the child or the check, or which one comes from the other, it's like the chicken and the egg.
Yeah, we were talking about before we got on RICO and how in Title 18 USC Section 1961 rather, there are at least 2 references to welfare fraud and lots of references to trafficking children and the Racketeer Influence and Corrupt Organizations Act. And if you can hack it down that way and show that they are basically embezzling money by going against these statutes, then that becomes a consequence where you can get damages for them basically embezzling or misapplying welfare funds. And I think that's a potential avenue of relief for parents also. But again, this is fairly sophisticated stuff. You have to see the you have to connect the dots and build your remedy very carefully.
Right. So, in short, in English, and in layman's terms, what can a person do when the rules or the laws say this in their case, and they're trying to use them in a different way? What is the temporary remedy for someone to try to enforce the rules and the laws that they see in these books and involve them in their case?
Well, Rule 11B2 of the Federal Rules of Civil Procedure and lots of state equivalents say that you may make a good faith argument for modifying, extending, or reversing the existing law, or to make new law. Now, that is done with a judge primarily, but in some states, such as Texas, it can also be done with a jury. You can demand a jury to hear your. In Texas, you can demand a jury to hear your declaratory judgment. You can't in the federal system. But obviously, it would be much fairer if we tried to get enacted in the state in the states and federal system the idea that juries could extend, modify, or reverse existing law or to make new law. You know what that would be like? That would be like we live in a democracy, because juries would become like little legislatures addressing specific problems. And so that's how it was in the early 19th century when Tocqueville wrote his Democracy in America. I think we need to get back to that system.
Yeah,
right now, it's pretty much up to the judges. And the judges are, and it's very difficult because the judges they have a vested interest in maintaining their maximum power, which is in the form of discretion. They have all these rules, many of which are contradictory, and so they can pick and choose which rules they want to follow.
Hey, Charles, question. You've worked for judges in the past.
Yes.
How is it when a judge is sitting on a case such as a dependency case, where he essentially is the discretion, he is the oversight, he is the rule maker for the case. How does he get paid?
Well, officially, he has a fixed salary, and that's it. Now, I don't know anything about kickbacks or investment policies or anything like that. Most people who become judges are extremely wealthy, especially in the federal system. They were extremely successful lawyers, and so they have very large investment portfolios in real estate, stock, bonds, everything else. And so I hate to say it, but they can actually, manipulate cases to favor their own economic interest, and it's almost invisible. Not completely, but basically, judges have to put their assets into what's called a blind trust, where basically they're supposed to not even know what their assets are, so that they can't do this. But of course, they know what they had when they became judges. They don't go senile immediately just by virtue of becoming judges, and so they'll remember what their interests are and what is going to be advantageous to them. And as far as and any of these programs directly funding the salary of judges, I don't know anything about that. I worked for federal judges, and I'm not aware of how exactly Alabama family court judges would ever be paid, except through the general funds raised by the legislature of the state of Alabama or Florida or wherever it is. And I've heard these stories that they're paid from specific funds, but I don't have any knowledge. I don't know anything about them being paid from the specific CPS funds or anything?
Well, I know that I was reading something about when a person files indigent, there is a certain amount of funds that are essentially levied to the court on the behalf of making sure that the whoever requested it has as fair of a hearing as they can have. But you know what happens when you have, like, I did indigency. I was granted indigency funding for court appointed attorney, but then the judge puts out an order saying that he's not allowing me to have the attorney. But I could damn sure bet he didn't say, hold on, let me refund the state's money.
You know, I really don't know. I mean, I've never heard of that. All I know is that I think I've told you, and I may have commented on this show before, that in the federal system, under 28 USC section 1915A, if you file indigency known in the federal system as IFP, in forma pauperis, in the manner of a pauper, if you file that in the federal system, you're basically setting yourself up to be discriminated against. You're setting yourself up to potentially, in some circuits, have your case decided by clerks rather than judges. You lose a lot of civil rights by going IFB in the federal system, and in the federal criminal system, they of course do provide complete access to either CJA or public defenders in the federal system, and it seems that these CJAs and public defenders are all instructed to make sure that the maximum conviction rates are maintained, and that all defense be limited in efficacy to something that will not materially change the law. And very rarely do you get any exceptions to that. So again, I have no knowledge about life under the St. Andrew's cross of the state flag of Alabama, which is now your emblem here. Also the state flag of Florida. But I like that. That's very elegant, by the way. You put up there your avatar. But I don't know everything, and I don't pretend to know everything, and I certainly don't know anything about how Alabama judges are paid or how Alabama indigent lawyers are paid. All I know is that everywhere there is great discrimination against people who don't have money. And that's just a sad truth of life. If you don't have money, and if you can't shovel out tons of money, you're at a terrible disadvantage. But I will tell you also that when they want to get you, they get you. Because I was telling somebody about the case of Moshe Leishner the other day. Maybe it was up here today, as a matter of fact. Moshe Leishner was a major foreign exchange trader in Los Angeles, and he was so rich he endowed a special Jewish community center in the San Fernando Valley, called it Chabad Center, and his donation was so big and so widely appreciated that Vice President Cheney appeared with him at the dedication of this Chabad Center in the San Fernando Valley. And then a few months after that, he opposed the Iraqi war very publicly. He opposed war in Afghanistan. And he found himself suddenly arrested and indicted for foreign exchange fraud. And he paid $5 million for defense attorneys, and they advised him to plead guilty because he'd get out immediately. They'd work a deal where he'd get out of jail immediately, and after that $5 million, he was sentenced to 20 years.
All right. Hey, guys, we got Kenneth back here ready to give us a few minutes of an update about his case here. If you remember, well, Kenneth, do you want to give everybody a little brief synopsis of what you've got, what happened to you, and where we're at? So I know you got a ton of stuff that we're waiting for here, but maybe just give everybody a little, hey, I'm Kenneth, and I'm in a really screwed up situation.
Yeah, I am a stepfather, and I've been dealing with poor father.
Right.
Yeah, because we know how the system is. Our case has been going for, I want to say, 28 months now. Started back in January of 22. Essentially, my visits were cut off when the child was 22 months old. I haven't seen her since. After I accomplished my case plan, after having picked myself up from losing a job and a vehicle and a place to live to having all that back, the judge hit me with a no contact order. I've had 2 court-appointed attorneys. Neither have been successful in getting the no contact lifted. It wasn't what you would call a traditional no contact order. It was just put in the notes. Our next hearing is Friday the 13th, which is going to be fun.
Yes.
And
what's on that hearing?
That hearing is going to be either an extension of the current reintegration plan, which is to be done with the biological mother, because they have not established a biological father yet. And that's just, I'm not even going to get into that. That's a pain in the butt. But
well, are you still in play with that? Is that still something in play with you, correct? That you are the father?
In my eyes, I think they tampered with proof, you know what I mean? But that's, okay, I'm going to stand on that.
Yeah.
Because it's been, it's been proven that they do stuff like that. They've tampered with drug tests and other tests.
Right. Yep.
To, further their agenda. But it's either, this next hearing is either going to be extending this case yet again, or moving forward with terminating parental rights.
Okay. Ugh, it just makes me sick to hear people say things along that, to hear people say things like that, like it's disgusting. The fact, and we were talking about this the other day. I've always said this, and so is there very many, is that it's like getting the death penalty. But you know what? It's really not, because sometimes people don't even die on death row. People are on death row. They're there for years and years and years and years, and they die of old age in these jails. Not us. Man, they terminate your parental rights, bye-bye. And most of the times before they've even terminated your rights, they've already taken the damn kids from you. So it's not even close to like the death penalty. Not even a damn near close. And what are you hoping for, Kenneth? What are you hoping to, I know what you're hoping for, but I know you don't want to say anything, tricks up your sleeve. But Charles, this guy, were you on when Kenneth was on with us before?
No, I don't think so.
So this guy, they did everything that they could to say that he was not good enough to be a dad and the father and his wife and all this. They broke up his family. And this guy since then has replaced everything except for his wife, because they've separated them by force and then, that way. But he's done everything that possible. And then they started the determining, saying that he wasn't the father. And he's been with that baby since minus day one, right? Kenneth, you guys were married at the time, correct?
No, we were.
We're not married, but you were.
I entered the child's life when she was 3 months old.
Okay.
We got married when she was 10 months old.
Okay.
And essentially, I had been there for everything. Teething,
right.
Transitioning from breastfeeding to bottle feeding to solid foods to reading books to her, trying to help her learn everything from walking to running to swimming, the whole 9 yards.
Yeah. And the father had nothing to do, or the biological whatever he was wanted nothing to do with him, or they couldn't find him. I couldn't remember which
No,
one it was.
they found him. He's just not wanted nothing to do. He got in trouble when she was like 2.5 months old, and he did not even try and come and say, "Hey, I still want something to do with her." He just disappeared. I mean, we knew where he was. We knew who he is, or we know who he is, or at least we think it's him. But he refuses to cooperate in any shape, way, form. He's just not doing it. I mean, case has been going for 28 months now, like I said, and when I look back on my documents, and I only have one pamphlet of the original case plan, somewhere in there it stated that they were requesting DNA, a paternity test from him, but they also imposed that on me and told me that if I didn't do it, I was going to jail. So I ended up doing it under duress.
Right. And then I know the last time too that we had talked about possibly even getting together with that father and trying to give him, make you the, like give up his rights, right, and then allow you to do it. Did you get any work on that?
Yeah, I haven't been able to contact him. He doesn't answer phone calls. He doesn't answer messages. He doesn't even answer his mail from, when he gets these letters from DCF to,
right,
hey, go do this. We need you to do that DNA test. No, but he's got an attorney.
So, Charles, this guy wants to be in this.
Where's your case again?
It's in Kansas.
Kansas.
So he wants to be involved, and he wants to be the father, and he wants to get this thing going. Anything that you, and the supposed father, sperm donor man, he doesn't want nothing to do with this kid. And this guy's fighting to try to be in this kid's life. And the child's being terminated on this side. It's really a big blunder. Like, do you know anything about step-parent laws or step-parent rules or anything at all that this guy can look at and try to move in his favor?
I really don't know Kansas law at all. I'd be lying if I said I had any brilliant ideas on that. I mean, I'd have to look at the case. I don't have crystal balls. That sounds strange, doesn't it?
No, yeah, I got brass ones.
Yeah, the thing is, they won't give me any of the information. Like, I've requested the court transcripts, and I went through my attorney, and he's kind of leery. He's like, if we do that, the judge could terminate your party of interest. And when I requested it from DCF, they said it went straight to St. Francis, which is the organization at St. Francis Ministries. And they told me that they do not give their case information out to anybody, not the parents, not the family, nobody.
Well, I mean, you may have to do what's called a collateral attack and file a suit specifically concerning the law as it's being applied. You've only got the one case right now that you're involved in?
Yep.
Okay, well, you may want to consider, making a list of all the rules that they've said they're applying to you, and thinking about challenging those rules or those laws in a separate action. You have no contact with your child at all?
I haven't seen her physically. I haven't been able to interact with her since she was 22 months old.
How old is she now?
She is going to be 4 next month.
So basically for 2 years.
Yep.
Well, I mean, it's not an easy solution. It's not an overnight solution, but I would think that if you're serious about trying to do this, that you should try to challenge outside the framework of the family courts, and instead you challenge the family court framework itself. Kansas, from what I know, is fairly open to that sort of collateral challenge to its laws. I've heard good things about Kansas, that basically their courts are open and that they're willing to consider reasonable suits regarding the reform of the laws.
Well, I've tried to figure out if I could pursue this outside of the jurisdiction that the case is in.
Okay, remember what I'm saying. I'm not saying go outside the jurisdiction. You still need to be in the same area. I'm saying go outside of the family courts into regular civil courts. Don't seek a family court remedy. Seek a civil law remedy.
Okay, civil law.
Constitutional remedy. Try to come from outside the family court system to attack what there's. Like I said, the first thing you want to do is list all the reasons that they've said you're not entitled to information, that you're not entitled to participate. List everything that's been said against you, and try to think it is, and look at Article 1 of the Kansas Constitution. I'm pretty sure in most states, Article 1 is the Bill of Rights. I haven't looked at Kansas in the past, year or two, so I don't remember exactly. But I think that Article 1 of the Kansas Constitution probably is a Declaration of Rights. If not, look up the Declaration of Rights in the Kansas Constitution. And often you can find more rights outlined in the state constitution than in the federal constitution. And you'll find that they're actually violating a lot of the state's own constitutional rules. So, I mean, that's where I would start. Do your homework there, and maybe we should talk, outside this show or something.
I could give you my email in the chat, or
give it to them. Give it to them. Don't announce it publicly here or anything.
Well,
the host has
the private one. You can put it in the private one.
Yeah, the host has it.
Yeah, I'll send it to you. I'll send it to you right now, Charles.
Okay.
There you have it. Man, it's just. But you already have. So if you don't get this continuance on the 12th here, boy, that's gonna force your termination to come flying right up, huh?
Yeah, the continuance could possibly take place on Friday. I've noticed that they've made a habit of doing it on Fridays with us, so we didn't have time to go and look at anything else, or even talk to our attorneys after the fact.
What shit? How long since you've seen your child?
26 months.
Are they gonna have him for abandonment, Charles, with no contact to that child?
Again,
I don't know. I don't know if they're gonna. I don't know what they would do to me, but that other guy, he's been out of the picture even longer than me.
And I only say this because for myself, when they stopped my visits with my daughter because of my podcast, their whole goal was to get to the 6-month period of no contact with my child. So then they brought me into there, and they used abandonment to stack up on that, because in Maine it's 6 months with no contact to your child. It's considered abandonment, and then they did that knowingly, and they just did it. They knew what they were doing because they actually rescheduled my court hearing to get it to that point, to the 6-month point, to the day. So they knew what they were doing. But that makes me get a little bit nervous now, Ken, with you thinking about that. I don't know what Kansas's abandonment laws are, but if you haven't spoken to your child, even if it was their fault or not, they're still able to pull that abandonment card, and that's definitely one of the prongs that they need for a termination of parental rights, and that really sucks. So definitely, I would talk to whomever and figure out what that rule is, because that's going to be one that they'll throw right at you, man, and there's going to be nothing you can do about it.
Yeah, I've tried to talk to her, and they said, no, you can't do that.
Man, I didn't even, just that last time we spoke, I didn't even think about that. Shit, I'm sorry, dude. You could have had a little bit more room to look for stuff. Like I said, I would look up Kansas's abandonment law and see what the time frame is, first and foremost, and get yourself privy and see what you can do about getting out of that situation, if it may be, because it's very important. And then the other thing that I recommend, even though I'm not a lawyer, is make sure you put as much information in your files so that you can get that into that TPR trial. Because if you're going to appeal, you need to have stuff to appeal. So make sure you get as much information into your trial that you can. Questions, arguments, complaints, all of that stuff. Get that in there, because they're very good at leading you down that path to have nothing to appeal. You call these appeals lawyers after your TPR hearing, and they're like, they didn't do anything. There's nothing, because all you get to challenge in the appeals is what took place in that trial day, like in that courtroom. So make sure that you get, make sure these questions are brought up, make sure they're asked, because otherwise the past years of investigation don't mean a darn thing. Because you're only there to challenge the law in the way or whatever, right? What's the definition, Charles, for what you're allowed to ask for in appeals? It's about the trial that day, right? And the laws and the things that were
again. That's why you want to. That's why I'm telling him to consider a collateral attack, because if you go outside and have a new proceeding, then you're not bound by what happened in family court. You're only bound by what happened in family court if you directly appeal what the result in family court. But yeah, whenever you have a trial or proceedings in trial court, it's not necessarily a trial, but whenever you have proceedings in a trial court at what's called a court of first instance, you're bound by the issues you raised and that the other side raised, and that were or could have been decided in that court of first instance.
All right. Well, I'm going to get Kenneth's information to you, Charles, so you guys can do that. And then we're way over our time. So, Kenneth, want to join us for the last comments? You want to do that? Charles, last comments for tonight?
Hey, it's May 3rd, and it's been an interesting couple of weeks for me, and I think everybody else too. But the key to everything is you've got to be creative when you're fighting. If your rights are being suppressed, don't look to the government to defend you. You look to your soul and your imagination and your feeling of justice.
Oh yeah, that's good. That's good. Thanks for that, Charles. I like that. Melissa, last comments from you?
Know your rights. Do as much studying as you can. Don't be afraid to ask too many questions, because one of those questions may lead to an answer that you need. Never quit fighting.
Kenneth, last words from you, buddy. Yes.
Worry about people calling you a freak or a conspiracy theorist or a nutcase or anything like that. Those are all compliments.
That's great. Kenneth, anything last words you want to throw out there, bud?
All I can say to anyone who's watching is don't trust CPS.
Yeah.
Don't let them in your house. Don't let them on your property. And don't believe a darn thing they say.
I'd just like to expand that to say, don't trust the government, period.
Right. Right. All right, Herbert, last words from you, my brother.
Yeah. I just want to say, Kenneth, if it doesn't feel right, it's not right. And you really should look into it. Don't wait. Don't think it's going to go away. It's going to disappear in midair and everything's going to be okay. No, you really need to check with people that know. You don't have to invent the wheel. The wheel has been invented. A lot of people are going through what you're going through. So seek advisement from people. Open your mouth. Say something.
Mm-hmm. That's good advice. That's good stuff. All right, guys. I want to thank you all for the weekend. Thank you all for this week.
Hey, Darren.
Yes, ma'am.
There is a case law out of Tennessee that Kenneth should look up. There is it's an active going lawsuit. It is step-parents and grandparents who have been denied their rights as a parent are suing the state of Tennessee.
Okay. You hear that one, Kenneth, right?
Yeah, I was writing that down.
All right, cool. Thanks for that, Melissa. Parents suing. I'm gonna write that too. Suing Tennessee. All right, step parents, we're coming for you. We're gonna help you guys out too. We're doing all we can. All right, guys, thank you very much. We'll be back with you guys next week, Monday. So you guys enjoy your weekend. Kenneth, we'll catch up with you soon. Maybe we'll get in touch with you right after, or not. Maybe we will get in touch with you. Maybe the day before, and maybe the day after to see how things are going with you. Maybe give you a little pep talk or something like that. So, and I'm gonna get Charles your email so that you guys can get in touch. All right, guys. Thank you very much, Charles. Good to see you back. It's so great. Melissa, as always, thank you so much. And I'll talk to you shortly, I'm sure. And that's it, guys. That's it for the Friday night edition of CPS Victims Hunting for Justice. Let's all hope and pray for Kenneth, because, it's a damn shame when someone loves a kid that much. And, they're not letting them be a part of the life where the kid's not going to have a dad as it is. Let that man step in and be a father to that kid. Don't forget to check out, don't forget to like, subscribe, check out abolishcps.com, all kinds of things. Most importantly, get CPS out of your house and out of your life this weekend. Be safe, everybody. We'll be back Monday. I'm CPS Punisher. I'm out of here.